Welcome to Looking at Legal Stuff. Today we have 9 hearings in a case with a couple where dad has filed a motion for contempt after he claims mom took their daughter and moved to Oregon with her, despite the fact that she didn't ask the court for permission to move, nor did dad agree with it. Dad says he's also had the child full-time for the last month after mom came to him and told him that her home wasn't a safe environment for the child, and now he's worried for her well-being if she were to return to mom's care. Dad has also motioned the court for a temporary restraining order to halt any visitation between the child and her mother, because he says he's been informed that mom's boyfriend is abusing drugs and using those illegal substances in her home. What does mom have to say about these allegations? Let's find out.
The next on my list, I have 3 cases with Monique Barnes and Brandon James. Are you all present?
Yes, Your Honor.
Okay.
Yes, Your Honor, and it's O'Brien, not Barnes.
Oh, thank you, Monique O'Brien. Thank you. Don't know why that said Barnes. And Brandon James, this is 223-0018408. So there's several things noted on my docket for today. 2 of those are show cause motions from Mr. James, I believe, regarding the fact that he alleges Ms. O'Brien has moved without going through the formal relocation process with this court. There was also a restraining order request. I don't see that we've had a hearing on Ms. O'Brien's relocation request. Let me start with Mr. James, since he filed the show cause contempt motions. What is your position today, sir?
Back in late July, Miss O'Brien told me that she was going to move to Oregon because she didn't have any other options. I expressed that I did not want my daughter moving to Oregon, and she went ahead and did it anyways. So that is why I did the contempt paperwork. And then in September, she told me that right now where she's living, it's not physically or mentally healthy for our daughter, and asked me to take her full time. She did ask for a weekend with her, and I gave that to her because I'm not trying to keep money from her mom. And then during that weekend, she told me that she was not going to give me Ryan back after our daughter's been living with me consecutively for just about a month. I got her on a schedule. She has a regular bath, dinner time. She gets up, she goes to school in the morning.
Well, yeah, so hold on. I think we're getting a little far off track. So I need to be real specific on what we're doing here today.
Okay.
So a couple things. Ms. Barnes, have you moved to Oregon with the child?
I have since relocated back to Washington.
You are back in where in Washington are you?
In Longview.
You are in Longview? Okay.
Yes.
And then where is the child? Are you all still adhering to the parenting plan in place, or has that changed?
No, she's still with Brandon.
Okay. Mr. James, is that all correct?
Yes, Your Honor, she is with me, but as of just the other day, I was informed that Miss O'Brien has moved her biological mom in with her and her boyfriend in her studio apartment in St. Helens. From
That
Miss
is
O'Brien.
incorrect.
Hold on just a second, ma'am. I'll come to you in a second.
That information came from Miss O'Brien's family.
Okay. So, Miss O'Brien, you're asserting to the court that you are back in Longview, Washington?
Yes.
Okay. I don't see that you have filed any response to the show cause motion. I do see that you were just served with the amended show cause contempt motion just on October 18th last week. Do you believe that you have documents that you could prove to the court that you reside in Longview, Washington?
At the moment, no, I do not, but I can get the documents.
Okay. What I'm going to do just on the show cause contempt regarding the move, I'm going to allow, how much time do you think you need to get that evidence? If we set you out 2 weeks, could you have that?
I can do my best to get that.
Okay, so, sir, on your two show cause contempt motions, and mostly it's an original and then an amended, I'm gonna set this to November 8 at 9 a.m. And ma'am, what you'll need to do is just serve any responsive documents on the court and Mr. James that shows where you currently reside.
Okay.
Okay, so, and Mr. James, I'm gonna come to your restraining order request in just a minute. But first, Ms. O'Brien, you had filed a notice of intent to relocate. Are you intending to strike that?
Yes.
Okay, so you're no longer asking the court to rule on your ability to move?
Yes.
Okay, so I will note that you are striking your notice of intent to move with children that was filed with our court October 11th, 2023. So we'll take that off the table for discussion at our next hearing. And then Mr. James, let's move to the last issue I have in front of me today, which is the temporary restraining order you requested.
Yes, Your Honor.
And this obviously would preclude any sort of visitation with Ms. O'Brien. Are you asking for that restraining order to continue?
Yes, Your Honor.
And can you give the court the basis for requesting that it continue?
I'm not sure if you have it in front of you.
I do. I have it in front of me. I'm just
Okay.
asking for your oral testimony on why you're requesting this.
Because I have been informed that Miss O'Brien's significant other has abused drugs and has done illegal substances in their house.
Ms. O'Brien, do you want to respond to the request for a restraining order?
I do want to say that I no longer have a significant other.
Okay.
With moving back to Longview, we ended our relationship.
Okay, so here's what I'm gonna do. I will note that a temporary ex parte restraining order just through today's hearing was signed by Judge Evans on October 13th. I am going to reissue it just on a temporary basis through the date of our next hearing, which I set for November 8 at 9 a.m. The reason I'm doing this is that I think there is a declaration filed that does support the restraining order that causes me some concern about the safety of the child with Ms. O'Brien currently. But I think more appropriately, because there were significant concerns about Ms. O'Brien failing to comply with court orders and moving the child out of state without going through the proper procedures, I think the restraining order is also appropriate through the date of our hearing. I will revisit the restraining order issue on November 8th. And Ms. O'Brien, what I would ask from you is to submit any documentation regarding sobriety and safety in your home. I would also ask that you again provide the indication that you are residing back in Cowlitz County. Okay?
Okay.
Okay. Any questions for me from the parties? Otherwise, I have signed the restraining order. It does not need to be served on you, Ms. O'Brien, like the last one, because you are here to hear about it. But I would recommend that you come get a copy of it because it does preclude all contact with Mr. James and your minor child with the initials RWJ. You're not to go within 200 feet of the protected persons. You're not to own, possess, or control firearms. I'm not issuing an order to surrender because of a case called State v. Flannery, but I am stating on the record that you're not to own, possess, or control firearms. Any questions?
Just where would I be going to, like, get the test done? I don't.
Any sort of UA clinics where you can get a UA, is that what you're asking?
Yeah.
Yeah, I can't give you any specifics, but there are agencies all throughout Cowlitz County that will do UA testing for you.
Okay.
Okay, and then I'm going to reserve on the contempt motion until our next hearing on November 8th. Okay?
Okay.
All right, Mr. James, anything else that you need from the court?
No, Your Honor.
Okay, thank you both. You're free to log out.
Thank you, Your Honor.
Thank you.
Thank you.
See who we have present. I saw Brandon James here. Are you able to unmute?
Yes, Your Honor.
Okay. And then Ms. O'Brien, I see you there. Are you able to unmute?
Yes.
Okay. So when I reviewed this file, Ms. O'Brien, I had been hoping after our last hearing that you were going to be filing proof of being in Cowlitz County versus out of state, but I don't see that you have filed anything.
Yeah, so I don't know exactly what I need to
Are
like
the
put
are
in
the-
as a proof.
are the two of you able to turn your cameras on?
Yeah, hold on.
Okay.
Okay, so I don't know exactly what I need to like turn in as a proof of like address.
Yeah, I just need anything that shows me, because the allegation is that you are not currently living in the state of Washington, and it
So
sounded
like
like
if I put like a bank statement or like a proof of change of address, would that count? Like,
I just give me anything that shows that you are residing in Cowlitz County, like you've indicated to the court.
okay.
Okay. Mr. James, where are you at are you satisfied that she is residing in Cowlitz County? Have the two of you had any contact?
No contact. I don't know if she is living in Cowlitz County or just saying it just because she hasn't provided that,
Right.
or the UA that was requested as well.
So the other question I have, and I'm just looking here, you did at our last hearing request the temporary restraining order. And I said we would address that further today. I did reissue it through today's date. Are you still believing that a temporary restraining order needs to be in place?
I believe so.
And can you tell the court why?
So last time we spoke, I was given some misinformation. I was told that someone moved in with her, but after our court, come to find out that she moved in with other people who have not the best habits. I would feel better if we can get a expedited UA or a substance abuse evaluation before we lift that.
Ms. O'Brien, have you done a UA recently?
No, so I called to get it done, and because the courts want it, they need someone to release it to. So like we need a guardian ad litem appointed to release it.
Okay. Have the two of you ever had a guardian ad litem on your case?
No.
No, but I did request for one to be on this case.
Okay. I do think it makes a lot of sense in this matter. It's one of the things I made in my notes when I was reviewing this file. And I think the guardian ad litem serves a few purposes. One is it is someone that the test results can be released to, but Ms. O'Brien, they can also release them to the court if you sign a release of information. But with a guardian ad litem, you sign a release of information and the guardian ad litem can get those results. I think it's a great idea. I also think we're probably going to be dealing with at some point when the restraining order is lifted, assuming it is, with going back to what visitation looks like. So who would be our next three GLs? Twyla Corey. So I'm going to read off a list of 3 names. If any of you object to any of those 3 names, please tell me. The first is Twyla Corey. Keith Lawrence. Second is Keith Lawrence. Heather Kale. And the third is Heather Kale.
I personally have no objections to any of them.
Okay. Ms. O'Brien, any
I would
objections?
just prefer it be a female.
Well, the first on the list is Twyla Corey. So since there's no objection to her, it will be Ms. Corey.
Okay.
And I'll get that order filled out today. I'm also going to indicate specifically that she can follow up on the UA results. It is going to take a little bit of time, probably, for her to get up to speed and get those UA results. I will reissue the restraining order through the date of our next hearing. I do have concerns about Ms. O'Brien, the fact that you haven't submitted proof of residential location to us, and given Mr. James' concerns regarding who you may be residing with, I think in the best interest of the child, we should continue with the custody as currently happening with the restraining order in place.
I just want to be able to video chat her.
Mr. James, do you have any objection to video chat like FaceTime or Zoom?
We could video chat.
Okay. How old is the child?
She'll be 3 in
2.5.
April.
Okay. So here's what I would say. I mean, I think it's going to be a little bit difficult to video chat with a 3-year-old. The attention span is going to be very short.
We've done it in the past.
Okay. What Mr. James, would that be through your phone?
Yes, Your Honor.
Okay. And do you both have iPhones? Would that be FaceTime?
Yes, Your Honor.
Okay. I'm going to specifically put as an exception in the restraining order that FaceTime chats with child are allowed. And let's say up to 10 minutes a day. Will that work for the parties?
Yes, Your Honor.
Okay, I'm guessing it won't last 10 minutes with a 3-year-old, but I'll allow it up to 10 minutes a day. Mr. James, do you want to be the one to initiate those FaceTime calls?
Yes, Your Honor.
Okay, I am going to include that just because you are the protected party in the restraining order. I'm going to state Mr. James to initiate calls. Do you have the current contact phone number for Ms. O'Brien?
I believe so, unless she's changed it since we started court.
I have not changed my number.
Same number.
Okay.
Okay. So I will put that into an order. What I would like to do is set you all out. Where did my docket days go? To we could do December 6th. That's a little less than a month out. To see how this is going and see if Ms. O'Brien, you've been able to get the UA, get the GAL on board. Will that work for the two of you?
Yes.
Yes, Your Honor.
Okay, December 6th, 9 a.m. And then lastly, we have to determine who is paying for the GAL. So let me first ask you, Mr. James, what is your current monthly income?
Around $2,000.
Okay. And is that take home pay per month?
Yes.
Okay. And how many dependents do you support on that income?
Including myself?
Not including yourself, other than you.
Two other people.
2 others. Okay. Okay. And then Ms. O'Brien, what is your current income?
I'm currently unemployed.
How long have you been unemployed for?
2 weeks.
Oh, excuse me. Okay, I will find currently that you both would qualify for the GAL to be paid for at county cost. That means that you won't be responsible for payment of the GAL fees. What we do typically is at the end of the case, we will re-review your income to see if there's any reimbursement that you would owe to the county for the GAL report. But at this time, it'll be county pay. Okay. And I'll get that order signed shortly. When the GAL is in touch with you, the most important thing is they have intake paperwork. Get that back as quickly as possible. They will reach out to chat with both of you. They will likely want to chat with your child. Any roommates, Ms. O'Brien, that you're living with, they'll want to be able to talk to. So just make sure you're staying in contact with them so we can move your case forward.
Okay.
All right, thank you.
Your Honor, I do have a couple of questions.
Okay.
So as far as the contempt paperwork goes, are we going to address that on the next court case?
Yes,
Court
we
date?
are. Yes, we are. Because
Okay.
the contempt is, thank you for bringing that up. Because the contempt is so tied to Ms. O'Brien providing this proof of residency information and where she's currently living, I would like to set that forward to our December 6th date. But I am going to reissue the temporary restraining order through December 6th.
Okay. And what happens if we do not get a response about the residency?
Well, I think if we don't get a response about residency by December 6th, we're just going to move forward. I think Ms. O'Brien failing to provide proof of your address probably tells me that you're not residing in Cowlitz County. So I would really
The thing is, we were waiting for an email back from the landlord about putting me on the lease.
Okay. So just strongly encourage you to get any small shred of evidence you have that you are residing in Cowlitz County again to the court before December 6th. Okay.
Okay.
Okay. Anything else?
Yeah, one more question.
Okay, go ahead.
How about the FaceTimes? Is there set days or times?
I
It's up to you.
wasn't gonna set specific dates or times since Mr. James, it'll be up to you to initiate.
Okay.
So I'll just let you coordinate that.
Okay.
Okay.
All right. Thank you, Your Honor.
Yes, thank you both.
Let me go to 9 and 10. Monique O'Brien and Brandon James. I have this on, let's see, Ms. O'Brien is there. Mr. James, are you here?
Yes, ma'am.
Okay. I have two things here. One is a review hearing for essentially status of GAL. We also have a contempt hearing, it looks like, that was filed on November 8th. I did indicate I do want to take that matter because we were previously here on November 8th. And I did indicate we'd move forward on the contempt motion today. We did just very recently on that date appoint the guardian ad litem, and then I reissued the restraining order temporarily through today's date. So let me first do this. I'll turn to Ms. Corey. Thank you for being here. Any updates you can give the court?
Yes. Thank you, Your Honor. This one has been a little slow getting out of the gate. I have not yet received intake back from Mr. James. I do have appointments later today with both parties. I did receive Ms. O'Brien's hair follicle test. She was ordered to do a UA, but she went ahead and apparently did a hair follicle test, and that's the 5-panel with extended opiates, and everything came back negative.
Okay.
So then I haven't yet seen any proof of her living in Cowlitz County be filed with the court. Also, after I really hate to try to make a recommendation before I've actually spoken at length with the parties, but after reading the court documents that have been filed, I'm kind of wondering about a mental health evaluation for Ms. O'Brien.
Okay. I appreciate that input. Ms. O'Brien, we're going to start kind of step by step. Thank you for doing the hair follicle test. Very glad to hear that it was negative. Appreciate you doing that. I haven't seen proof yet that you're residing in Cowlitz County. Have you been able to come up with those documents?
So where I was staying when I first came back I had to move, so I don't have anything that has proof of where I'm currently living until after I get my first paycheck.
Okay. Are you still in Cowlitz County?
Yeah.
And what is your current living situation? Are you living alone? Do you have roommates
I'm living in my grandparents' house
at
with them.
with your grandparents?
Yeah.
Okay. Are you currently undergoing mental health treatment?
No, because I don't have health insurance currently.
Okay. I do think a mental health evaluation makes sense. Ms. Corey, are there, for someone without health insurance, what are the local options?
Boy, I don't know of any.
Okay.
Um,
Ms. O'Brien,
perhaps-
go ahead. Go ahead, Ms. Corey, sorry.
I'm not sure if you're on state medical.
I'm not, because my stepmom put my daughter on hers. So the state wants $300 a month for insurance. The state,
Okay.
and I can't afford that.
I don't know of any other alternatives.
Ms. O'Brien, at this new job, will you have health insurance?
Not until I've been there for 3 months.
3 months, okay. Well, it sounds like maybe I do think a mental health evaluation makes a lot of sense in the long term here. Maybe I'll hold off right now, just if I order it now and it's not even a possibility for you, I think that's just kind of setting you up for failure. But I do appreciate the recommendation and I would like to revisit that when we can. Let me ask Mr. James, what is your request today? I guess knowing that Ms. O'Brien is living with her grandparents, are you still requesting that a restraining order remain in place? I don't know if you're familiar with her grandparents, if that's a source of concern for you.
I would like to request one until we could get a little more leeway on that mental health. Now that I know that she passed her drug screen.
I just
that
want to
is-
know if I can get visitation at my parents' house, like supervised with them.
Like with your grandparents there?
No, at my parents' house, which is close to where Brandon lives, with my parents present.
I think I would like to address that after Ms. Corey's had time to talk to a few more folks about this. I mean, again, she's so recently appointed. I would want to make sure that that is a safe place for her. So my recommendation, especially given the time constraints we have here today, would be to have you all come back in 30 days. I will reissue the temporary restraining order just for that time period. And then we'll come back in 30 days and have more input between the parties and Ms. Corey. And Ms. Corey, maybe, since it sounds like the request might be supervised visitation with the parents, maybe we could get some input on your opinion about the minor child's grandparents, I guess, and whether that feels like a safe supervised visitation plan.
Okay. And there is a interim hearing already scheduled. I believe it's January 3rd.
That would be the date I would set this anyway.
Yes.
So
Yes.
why don't we go ahead and keep that date and just set you all over to that date. I do want to briefly address the contempt motion though, because I know that's been hanging out there for quite some time. When I look at this case, in order for me to find contempt, I would need to find that there was kind of willful behavior that the petitioner, well, the petitioner in the overall matter, but respondent on the contempt issue, Ms. O'Brien, was able to follow the order, but was just refusing to do so. And I think what's much more likely in this case is that Ms. O'Brien is in a situation with a lot of life circumstances where she probably moved to do the best that she could. So I don't think that I can find under these circumstances that she's willfully refusing to follow a parenting plan the minute that it was filed. More likely than not, but again, I haven't seen proof of this. She relocated back into Cowlitz County because she's stating she's living with her grandparents. I'm assuming that that is true. She's starting a new job. She doesn't have a whole lot of income. So I am today going to deny the contempt motion. I am going to reissue the temporary restraining order through the date of our next hearing, 1/3/2024 at 9 a.m. And then I would like at the next hearing to discuss supervised visitation and whether amending or dropping the restraining order to accomplish supervised visitation makes sense, especially in light of the hair follicle test being negative. Does that work for the parties?
Yes,
It
Your
just
Honor.
makes it really difficult with my schedule.
Your Honor, I talked to Miss O'Brien the other day, and we have came to terms on when to FaceTime.
Okay.
She has told me her schedule. She's 3 on 3 off.
Can change though because of
Ms. O'Brien,
holidays.
please, Ms. O'Brien, please let him finish. Don't interrupt. Mr. James, go ahead.
She's told me that she works 3 days on, 3 days off. And when she does work, that she works from 6 to 6. And that she only lives a couple miles away from her work. So I don't see how it could be difficult to get the FaceTime visitations.
And I guess, am I being asked to change the times of the FaceTime visits, or Ms. O'Brien, what's the issue?
It's just with holidays, my schedule is a little different at the end, so it makes it difficult to be able to communicate with him if it would need to be rescheduled.
So in the restraining order, I indicate that video calls between mother and child are allowed.
Yeah. So I can't communicate with him if something came up, or like I had to work an extra day, or if my schedule changes for some reason. Because it can. I work in healthcare, so I can't. So if I missed a FaceTime, I don't want to get in trouble for that because
you're not going
to. I don't want him to hold it against me if I miss one.
It's not going to be held against you if you miss a FaceTime call because you're working. Absolutely not. I'm not concerned about that.
I still want that extra FaceTime because like I only get 3 a week. That's all he allows. So if I miss that one, then they'll cut it down to 3 because I was at work.
Your Honor, can I make a suggestion?
Absolutely.
Can I suggest that the parties use one of the co-parenting applications and that be allowed under this continuing restraining order so that there can be some contact regarding the visitation?
Well, yeah, I mean, I guess I think Ms. O'Brien, finish. Stop. My oral ruling was that FaceTime video chats with child were allowed for 10 minutes every day. I didn't set a specific time.
Yeah. I'm
not indicating it's only 3 times a week. I'm not anything. And inherent in the two of you working together is Mr. James. I expect that you make the child available when Ms. O'Brien is available. She's entitled to those 10 minutes a day with her child over FaceTime. So I'm not going to add anything extra right now. I expect you both to work together to make that happen. And it absolutely.
But if we can't have contact with each other, how are we supposed to make that happen?
Your Honor, let the record show that there's been times where Miss O'Brien has missed the FaceTimes, and there's been multiple times where I've called 2-3 times a night, just so she does get that time with our daughter.
It's happened once.
It's happened a couple times.
Okay, so here's what's happening is I'm trying to issue a decision. The two of you are talking over me. We're not going to do that. I am telling you that my ruling is there are FaceTime video chats with child up to 10 minutes per day. Mr. James, you need to make sure that works with her work schedule. Ms. O'Brien, if you miss one because you ended up working and by the time you called back, the child was asleep, nobody's going to hold that against you. This is your right. You have the right to have the FaceTime calls. It's not something that's going to be used punitively against you if your schedule doesn't allow it. But Mr. James, incumbent upon you, because you are the one requesting a restraining order and taking on the obligations of the child right now, you absolutely need to, and sometimes it will, you will be going out of your way to make it happen. But that absolutely is your responsibility right now as the custodial and residential parent, is to make sure that the child is staying connected with bio mom. Okay?
Yes, Your Honor.
So I will issue the restraining order, reissue the restraining order just through January 3rd, 2024. We'll revisit that issue. Please, both parties use good faith efforts to make those video calls happen. I think it's very important that this child sees and stays connected with bio mom through this tumultuous process for all three of you. Okay?
Yes, Your Honor.
Okay. All right, thank you all. We'll see you back on January 3rd. I will do the restraining order. I'll issue the denial on the contempt. Okay, you're free to log out. Thank you all so much.
Thank you, Your Honor.
Thank you.
Monique O'Brien and Brandon James, we'll call that matter next. That's cause number 223184-08. And I'll see if those parties are present. Monique O'Brien, are you here today?
Yes, I'm here.
Okay, welcome. And Brandon James, are you here today?
Yes, sir.
Okay, welcome to you, sir. And then Ms. Corey is also here as the guardian ad litem. I think we're here today for an interim report of the GAL report, if I'm not mistaken, Ms. Corey.
Yes. Unfortunately, I have not been able to move this case forward very much. I have met with Ms. O'Brien and also reviewed her hair follicle test that came back negative. But I have been had trouble getting intake documents from Mr. James. I did, after hours yesterday, receive those documents. There's about 4 pages missing from that, but I'm just going to try to move forward from this point and go ahead and set up a initial meeting with Mr. James to move things forward. My apologies.
Thanks for that update, Ms. Corey. I appreciate that. Mr. James, so it sounds like Ms. Corey got some documents yesterday. That's encouraging. And it sounds like she also needs an opportunity to meet with you to work on her report. Is that something you're in a position to coordinate and get that taken care of?
Absolutely.
Okay. All right. And Ms. Corey, do you have his contact information?
I do.
Okay. All right. So it sounds like there's more information that Ms. Corey needs to digest. She's got some information from Ms. O'Brien, and then she needs to get additional information from Mr. James and also take a look at those documents that came in late yesterday. Ms. Corey, do you have a time estimate that you think would be reasonable to meet, digest, and write and present?
Is the court looking for a written interim?
Not necessarily. Looks like you were appointed back on November 8th to address issues of mental health, substance use disorder, safety of the child. Generally, those can be addressed verbally.
Okay. And I don't recall if there is a date set for a final review.
I think there, well, let me double check.
Yeah, February 28th.
February 28th.
Yes.
All right. With that in mind, what is your suggestion, Ms. Corey?
Can we do perhaps a verbal interim around the first week in February, and then maybe move that final review out a few weeks?
Okay. Ms. O'Brien, what do you think about that?
That's fine. I just would have to know an exact date so I can get it off work.
Right, right. Mr. James, what do you think about that proposal?
That works.
Okay. So why don't we move this interim GAL report giving to February 7th, Wednesday at 9 a.m. So that'll be the interim verbal report from Ms. Corey after she's spoken with Mr. James and digested that information, and having spoken with Ms. O'Brien. We'll strike the February 28th date as far as a guardian ad litem final report. And would it be untoward, because if we have the interim report on the 7th, would it be better to have 30 days or say 45 days for the final report to be given? Ms. Corey, do you have any sense on that?
Just kind of based on how many reports I have due in that time frame, 45 would be better.
Okay, so that would be the 20th of March coming back. So does that work for the parties to come back on February 7th for the verbal interim report at 9 a.m. and then March 20th at 9 a.m. for the written final report? Ms. O'Brien?
Yes, that works.
Okay, Mr. James?
Yes, sir.
All right, so we will set that in stone. February 7th at 9 a.m. will be the interim report verbally. The 20th of March at 9 a.m. will be the written final GAL report. We're striking the February 28th date. Don't come then, but we will see you on February 7th and March 20th.
Okay. Does that mean the restraining order is staying?
I'm making no changes to any existing orders. So basically just did some scheduling here today. So no changes from what has been happening and has been previously ordered.
Okay.
All right, Mr. James.
And then real quick, Your Honor, that February 7th, is that a 9 o'clock as well?
It is, yes.
Okay.
All right. All right. Thank you all. Appreciate your help. That'll
you.
conclude that hearing. All right. Let's see. One moment. Monique O'Brien and Brandon James next. That's cause number 22-3-18408. And I'll call out those names. I have Monique O'Brien. Are you on the line today?
Yes, I'm present.
Okay. Welcome to you, Ms. O'Brien. Brandon James, are you on the line?
Yes, sir.
Okay. Welcome to you, sir. All right. And then I believe Ms. Corey is the assigned guardian ad litem. Ms. Corey, are you on the line today?
I am, Your Honor.
Thank you for your patience. I'm sorry I didn't get to your case earlier. So it looks like just procedurally, historically, we have Ms. Corey was appointed back in November, early November of last year. And then we had a hearing on the 3rd of January. And the review was to be had. And we changed the dates a little bit and moved. So somebody is speaking and they're not muted. So I need you to mute your phones actively on this call. All right, looks like it's rectified. So we changed the dates as far as the report. So interim review is to be today, and then the final review March 20th. And at the hearing in early January, Mr. James had not yet got the intake paperwork to Ms. Corey and was working on setting up a meeting. And I'm not sure if that went through and if there's any updates. So I'll start from Ms. Corey. Maybe give me a brief overview where you're at with the case, and then we'll go from there.
Yes. Since we last met, I have been able to visit Mr. James in his home. Ms. O'Brien has provided the court with proof of address that she's residing at her grandparents' address in Kelso. Mr. James gave me some information from social media that kind of sort of looked like Ms. O'Brien might be back in St. Helens. When I spoke with her about that, she said that she does stay there sometimes. We have not yet gotten any progress on the mental health evaluation, which I believe is key in this case. And
who's that evaluation for?
Ms. O'Brien.
Thank you.
Some concerns about the child being in daycare for 40 hours a week. Dad works part-time and his girlfriend works at the daycare where the child is enrolled. And it feels like maybe a little too much daycare is happening there. I also think that at this time, we should attempt to go to supervised visits for mom, either at her parents' home or at a professionally supervised facility. And that's about where I am right now.
Okay, thank you. Ms. I'll hear first from Mr. James. That information that the guardian ad litem shared this morning, had you heard any of that information, or is there any of that information that's new to you?
Yeah, so since our in-person meeting, it has been brought to my attention that the last time that Monique was at her grandpa's house was over a month ago, and that was just to get some of her stuff, and then she left again.
Okay. And then, so the guardian ad litem is recommending that there be visitations for Ms. O'Brien, either at the grandparents' home, her parents, or a professionally supervised facility. Do you have any input on that?
I would like to wait until we get that mental health evaluation done first. As far as the grandparents go, I'm not sure if they're on board with having it done at their house at this time. And they have also told me that she hasn't really been in contact with them lately.
All right. Thank you, Mr. James. Ms. Corey, have you been in contact with the grandparents of the child?
I have not.
Okay.
And that is why I said supervised either with the grandparents or professionally supervised. But I think it's imperative that this very young child has only been getting telephone visits from mom for quite some time. I think it's imperative that we reintroduce them in a safe environment.
How old's the child? Roughly?
2.5. She'll be 3 in April.
She'll be 3 in April. Okay. Yeah, Ms. Corey, did you have a proposed amount of time or frequency of the supervised visit?
I would say up to twice a week, 3-hour visits.
Okay. All right, thank you. Thank you. Ms. O'Brien, your input, please.
Well, so I can get the mental health evaluation, but it has to be ordered through the court before I can get that done.
Okay, so you're
but-
saying before you can get the mental health evaluation, there has to be an order from the court requiring that?
Yeah.
Okay.
I have started seeing a mental health professional, but I haven't been able to get the evaluation done due to it not being court ordered.
Okay. Okay, I think I can help with that. I could draft an order stating requiring Ms. O'Brien to obtain that evaluation and have the evaluator provide us the evaluation and recommended treatment thereafter. I think we can do that. I'll take care of that. And then Ms. Corey is recommending supervised visitations either by your parents or a professional supervisor. Do you have any input on that?
When we spoke this morning, I had told her that that's what I was looking for at this point.
Okay. So the one thing that I don't really know is kind of where the grandparents of the child are as far as providing supervision of the visits. And without that input, I think I'm going to default to a professional supervisor. Professional supervisors charge money, and it's usually not cheap. So that's where I'm leaning to requiring that. So ordering a mental health evaluation, I'll file that order. And then I would also file an order that allows for the professional supervision for up to twice a week for 3 hours per visit. So that's kind of the stopgap measure that I think sounds appropriate at this point in time. Any concerns related to that direction, Mr. James?
So when would that supervised visit start? And where would that happen?
Yeah. I don't know where a lot of the professional supervisors' facilities are located. I know that there's one or two here in the Longview-Kelso area. So I would assume it'd be in the Longview-Kelso area. And then I think it could start as soon as it can be established a relationship with that supervising agency. We could start as early as this week. I guess to give it just a fine point, we could just, so it's clear for everybody that the visits that would start on the 12th. So we'll just say that the 12th of February. That'll allow everybody to kind of get organized and get those visits set up.
Okay.
Other questions, Mr. James?
Nope.
Okay. Ms. Corey, further input?
Nothing at this time.
Okay. Ms. O'Brien, anything else from you?
No.
Okay, so what I'll do, I'll draft an order related to the starting of visitation, supervised visitation. It can start as early as February 12th. It'll be for up to 2 times per week for up to 3 hours per visit, and it'll be through a professional supervisor. So thank you. I appreciate the updates, and I'll get that filed and the party can look at that and digest it, and we'll just leave it at that. And then the next hearing would be on, I think it's on March 20th, but I think that's already been noted, so it would be back on the 20th.
Okay.
Okay.
Great. That'll conclude things for today. Thank you.
Thank you.
Thank you.
All right.
Your Honor,
Go ahead.
we are here today for a final review for 22-3001884-08 O'Brien v. James. And I need a couple extra weeks to get that one finished.
We're done.
I'm still outstanding a couple of collaterals that I need to speak with.
Okay, I apologize, Ms. Corey. Okay, my apologies, Ms. Corey. Go ahead, please.
I just need a couple extra weeks on this case. Still waiting for return calls from several collaterals.
Okay, thank you. All right, Monique O'Brien, are you on the line today?
Yes, I'm.
Okay, welcome to you. Brandon James, are you on the line?
Yes, Your Honor.
Okay, welcome to you also. So our last hearing, we're here back in the first part of February, and there was the GAL report was still being worked on. So want to make sure that, it sounds like, Ms. Corey, you have all the information you need to finalize things?
Pretty close.
Pretty close, okay. And expectation is that you'll get that information that you need?
Yes.
Okay. All right, so you're asking for a 2-week set over, is that correct? Or further?
Well, the following week after that is
10th?
there's no hearings, right? First week of April.
There are hearings the first week of April. The judicial conference is the final week of April going into May.
Oh, okay. I am actually out of town that week, so it would either have to be the 10th.
10th of April?
10th of April, yes,
Okay.
please.
All right, so let me touch base with the parties. Ms. O'Brien, there's a request to move this hearing to the 10th of April, which time prior to that date, Ms. Corey will have filed her report, and everybody will have an opportunity to review it and come to court on that day to talk about it. How does that date look?
It's fine. Her birthday's on the 7th, and I don't want to have to miss that.
Okay. Mr. James, how does April 10th look?
That's fine.
Okay. So at this point, as far as a birthday of the child on April 7th, let me just double check. Is there a parenting plan in place that currently addresses that?
There's a restraining order in place that.
Okay. All right. And so, yeah, it looks like
Your Honor.
that was entered on October 13th, October 25th, and the restrained party is Ms. O'Brien, correct?
Yes.
Okay.
Your Honor, I'm willing to work something out with Monique to where she can see right on her birthday.
Okay, that seems appropriate. So I'll let the parties address that. We will come back on April 10th at 9 o'clock in the morning to review the guardian ad litem report.
Okay.
Okay, that'll conclude things for today. Thank you.
Thank you, Your
Thank you.
Honor.
All right. I'll ask if any party has any request for a matter to be stricken or set over to a different date. And feel free to speak up if you do.
Your Honor.
Yes, Ms. Corey.
Unfortunately, number 8, O'Brien and James, I have not yet completed that report. My own fault. And would like a couple more weeks on that if possible.
Okay, let's make sure everybody's here on that matter. So if they have input on that. So Monique O'Brien, are you here today? Monique O'Brien.
I'm here.
Okay, welcome to you, Ms. O'Brien. And then I'll ask if Brandon James, if you're on the line.
Yes, Your Honor.
Okay, welcome to both of you. Were you able to hear Ms. Corey's request? She was asking that the matter be set over. Was it 1 week, Ms. Corey?
2
what-
would be ideal so that I
Two.
could get it to the parties to review before we appear again.
Okay. So the 24th is full at this point. So we'd either be looking at the week after, which would be May 1st.
May 1st.
Yeah. What is your take on that, Ms. O'Brien? There's a request that this hearing just be set over so Ms. Corey can submit her report and you all can look at it and come to court prepared.
May 1st would work best for me if we're gonna do that.
Okay. And Mr. James?
Yeah, that works.
Okay, we'll set the matter over to May 1st. That'll allow Ms. Corey to finalize her report, distribute it to the parties, and then we'll review it on that date.
Thank you.
Thank you, Your
Right.
Honor.
We'll see everybody then.
Sorry.
Thanks. Next matter I have is Monique O'Brien and Brandon James, cause numbers 22-3-184-08. I'll ask if Monique O'Brien is present or on the Zoom call.
I'm here.
Okay, welcome to you, Ms. O'Brien. And I see that Ms. Corey, the guardian ad litem, is present. Thank you, Ms. Corey. And is Brandon James on the line today?
I'm here.
All right, welcome to you, sir. And let's see. I see Ms. O'Brien has her camera on and just double checking with you, Mr. James. There you go. Great. I appreciate that. Thank you. All right. So we're here today for a review of the final guardian ad litem report. Ms. Corey did submit that. I read it. I'll just confirm with Ms. O'Brien. Did you receive a copy of that document?
Yes, Your Honor.
Okay, Mr. James, did you get a copy?
Yes, Your Honor.
Okay, so the guardian ad litem makes several recommendations related to kind of a tiered visitation process. And, if the parties still remain geographically separate during a period of once that week on, week off that's recommended, that there would be a reversion to a January 2023 parenting plan. Talks about a right of first refusal, talks about disparagement, no use of mind altering substances, including marijuana, talks about counseling and medication and the like, and no disparagement of that Mr. Walker not be left alone without one parent there. I think that's what I read. Ms. Corey?
Your Honor, I did want to mention that it was pointed out to me that in recommendation number 5, on page 24 of that report, it should actually read no language disparaging Ms. O'Brien should be allowed in the child's presence. Typo on my part. My apologies.
So replacing Walker with O'Brien?
Yes.
Okay, that's what I kind of thought, but I wasn't quite sure. So thanks for the clarification. All right, so that's the recommendation. So let me just hear from the parties. Ms. O'Brien, if you want to go first, and then we'll hear from Mr. James to hear what your thoughts are related to those recommendations from the guardian ad litem.
I think it's fine. It's been 6 months since I've had any physical contact with the child, so.
Okay, all right. Thank you. Mr. James, do you have any input?
Yeah, I do have one question about the tiered program. When Ms. Twyla and I were talking, I thought she said the tiers were going to be longer. I thought she told me that they're going to be like monthly steps, but in the report it said 2 weeks.
Right. So you were thinking you know, like the first tier is 2 times a week for 4 hours each, and you thought that would be for at least 4 weeks.
Correct.
Okay, and then the same for the 1 hour, 4 hours one day, and then a whole day, that would be another full month, and then the Saturday to Sunday would be another full month.
Correct.
Okay. So with knowing that her written report differs from that, do you have any concerns with that or any input you'd like to share?
I mean, is that set in stone where it's only 2 weeks?
Key word here is their recommendation. So it's a recommendation of the guardian ad litem, and then the court makes the final decision.
Okay.
So if you have input related to that, I'm certainly willing to hear you and hear both parties.
No, that was my only question, was the length of the tiered steps.
Okay. So if it were to be the 2-week tiered process, may not be ideal if I'm hearing you correctly, but you'd be willing to follow that.
I mean, yeah. I mean, if you say it's 2 weeks, there's not much I could do about it at the end of the day.
Okay. But do you have any strong, any reasons or rationale why you feel it should be a longer period of time?
Like I said, when Twyla and I were just talking on the phone, I thought she said that it was gonna be quite some time until we get to overnights, not just a month and a half. So it was just a little confusion.
Gotcha.
I
Okay.
can clarify that a little if you like, Your Honor.
Yeah, if you want to provide some input, that'd be fine.
So when I initially spoke with Mr. James about that, I was actually thinking of maybe just a couple of steps rather than what eventually evolved in my mind to be this plan, and to do that in a tiered plan with 4 weeks at each level. I think it would have spread it out a little too far unnecessarily. And that's when I made the decision to go with 2 weeks.
Okay. All right. Thanks. Okay. So I did review that the recommendations from the guardian ad litem in light of the different issues that have been raised, and also the prior court hearings that we've had. So I'm fine adopting that. I recognize that there's maybe some concerns about the length of the tiers, but I think overall the tiered visits, when combined with the requirement for involvement in counseling and proper taking of medications and prescriptions, I think that's really important. And I also think that the right of first refusal is important also. That allows all parents to be able to care for the child if one's available and another one's working or what have you. So overall, I'm fine with the recommendation, and I'll adopt each of those recommendations in whole. So as a general rule, let me touch base with Ms. O'Brien and Mr. James. When a court makes a parenting plan order, these tend to be fairly involved, and there's lots of different pages. Generally, the court will have time to do, just so you know, the court doesn't have clerks, doesn't have attorneys on staff to help draft things and the like. And so pretty time consuming to do a parenting plan order that's probably 10 to 13, 14 pages in length. So generally we'll rely upon the parties to prepare that. There's a Washington courts webpage that has the forms kind of laid out, and then you just fill in the blanks where the information's there. So I'm looking to see if one of you would be in a position to prepare that order, the parenting plan order, based on the guardian ad litem recommendations, and circulate that to all parties, and then submit it to the court.
I can
Okay.
do it.
Okay, we got a jinx right there, and you both said it at the same time. I generally, let's see. The petition was filed by Ms. O'Brien related to a parenting plan. And it looks like Mr. James also submitted a proposed parenting plan. So it looks like both parties are obviously capable of doing that. Let me just take a look here. One second. Okay, let's do this. I'll ask Ms. O'Brien to prepare the order, and then circulate it to all parties, Ms. Corey and Mr. James. And then let's return on the, and Ms., let's see, let's come back on the 29th of May. If all parties agree to what Ms. O'Brien has drafted, and of course it would be in accord with what the guardian ad litem has recommended. If all parties agree, then you could simply all sign off on it, submit it to the court, and I can sign off on it, and it'll be entered into the court file. If the parties disagree and there's disagreement, then we'd be here on the 29th of May, where you can express the disagreement, where the argument would be that Ms. O'Brien didn't get it right. And then we could resolve that and enter it at that time. So comfortable with doing that, Ms. O'Brien, and preparing that order and circulating it for signatures?
Yes.
Okay, Ms. Corey, were you going to say something?
Yes, I'm actually out of town that week.
Yeah, you mentioned that before. Let's set it for June 5th as kind of the backstop. Mr. James, any questions about that process?
No, Your Honor.
All right, so Ms. O'Brien will get that order out, circulated to everybody. If everybody agrees, you can sign off on it, submit it, and we'll get it signed and filed. If there's disagreement, then we'll be here on June 5th to resolve that disagreement. But if it's already been submitted, then you don't need to be here on that day.
Okay.
All right, very good. Any last questions?
So are we starting visitation then?
Yeah, the tiered visitation begins, let's have the effective start date. Let's have that start on Monday, the 13th.
Okay, and does that mean there's no longer a restraining order? So we can have communication?
Yeah, good question. The temporary restraining order, that's the one that was entered in, I think in December, is that correct?
I think it was October. I think it was in October.
October. Yeah, let me just make sure I've got the most current one here.
Did I fail to ask for communication via a co-parenting app?
Okay. Mr. James and Ms. O'Brien, when she says co-parenting app, do you know what she's talking about?
I know there's My Family Wizard, but it's expensive, so I would need to be able to get a waiver for that.
Yeah,
They do offer waivers.
So you'd have to make that application to the company itself. The court doesn't get involved in that process.
Okay.
Mr. James, do you have any questions on the co-parenting app?
I have no clue what that is, but I can get a hold of Twyla for more information on it.
Okay. All right. So as a general rule, a co-parenting app is basically it's a communication tool that allows parties to communicate with each other related to the well-being of the child and schedule and the like. And it records everything. And so it also allows phone calls, allows text messaging through the app. And so everything's recorded. And so there's kind of a monitoring element that Ms. Corey would be able to see and provide some, modicum of protection. And so everybody knows what the communications have been. So there's generally a monthly fee that it's like a phone app, and there's a monthly fee that has to be paid. So if the parties if you can't agree on that, or you've got concerns on that, I'll hold off on this at that point. And then we can come back on June 5th if you haven't come to an agreement, and then I'll make a decision on June 5th.
Okay.
Okay. All right. So then, Ms. O'Brien, your question, I don't want to forget that, related to the restraint order, whether that continues or whether that ends. Okay, so you're saying it was in October or before that?
I believe I was served with it in October.
I showed December 13th, 2023 restraining order that ended on January 3rd, 2024. And I don't see any additional orders beyond that. So it looks like by its terms, it expired on January 3rd, 2024.
Oh, okay.
Okay. All right. So we'll look forward to that that order if you can all agree to it. And if not, we'll be on June 5th at 9 a.m.
Okay.
Okay.
All right. We'll see you then. Thanks.
Your Honor, I'd like to request a continuance.
Okay. Tell me your name, please.
Brandon James.
Thanks, Mr. James. One moment. I'll call your case. All right. This is Monique O'Brien and Brandon James. Cause number is 22-3-184. We're on today for a presentation of from the order for the hearing on May 8th. I'll ask if Monique O'Brien is on the line.
I'm here.
Okay, you're present. All right. And then Mr. James, tell me the basis of your request to continue today's hearing.
I broke a tooth last night, and a dentist said that they could get me in for emergency surgery.
Okay. And Ms. O'Brien, what's your input related to the request to continue the matter?
I just want it over with.
Okay. So let me just double check. I'm looking through my file in which proposed orders have been submitted. Just pull them up here. All right, and then let me double check with you, Mr. James. It looks like Ms. O'Brien prepared a proposed parenting plan based on our hearing from May 8th. Did you receive a copy of that?
I got an email of it.
We got an email of it, okay. And when you looked over it, did you have any objections, meaning that Ms. O'Brien did not accurately capture or reflect what the court had ordered?
A couple.
Okay. And as far as your request to continue, those items, those couple items that you saw in the parenting plan, are those items that you could address this morning? And I'm just I don't mean to be unduly unyielding in the request to continue, but I'm just wondering if we could just take care of it today.
Yeah.
Okay. So then, Mr. James, can you tell me, when looking at that parenting plan, where your areas of disagreement are? Where you feel that she didn't get it right?
I just don't agree with her having majority custody,
Okay.
considering the fact that she admitted that that space is not healthy and she wants to put her back into it.
Okay. But besides the clear disagreement with the court's order, as far as the custody and the like, are there specific items where the court had ordered X, Y, or Z, and Ms. O'Brien put X, Y, and C or D, or got it wrong what the court had ordered?
No.
Okay. So the parenting plan here shows joint decision making between the parties for healthcare and school and educational issues. Ms. O'Brien is nominated as the primary custodial parent, and Mr. James has kind of that tiered approach, tiered custody for kind of the 2 weeks, and then another 2-week period, and then another 2-week period. Then it goes to the week on, week off. And so here she has written 2 4-hour visits each week for 2 weeks, then 1 4-hour visit and 1 all-day visit for additional 2 weeks, then 1 overnight visit for 2 weeks, and then week on, week off schedule. That looks like that's in accord with what the court ordered back on May 8th. So that seems fine. And then there's some midweek visits that are included for Mr. James. And then it talks about the summertime and then holidays. Any concerns with any of those, Mr. James?
No.
Okay. And the exchange location would be at the 7th Avenue Walmart in Longview. Okay. All right, so I think it's based on our just brief discussion here today, I'll deny the request to continue the matter based on the input from Mr. James and Ms. O'Brien, and I'll sign that proposed order as it fairly reflects what the court had ordered previously. So if either party needs a copy of this order, I didn't make any alterations to it. I've signed it as presented. You can get a check with the clerk's office and get a copy of it. Any questions, Mr. James or Ms. O'Brien?
No,
So when does it start?
So I think it's the effective date is today. It's signed today, so that should commence today as far as the effectiveness of the order. Okay, Ms. O'Brien, did you have any questions?
no.
Okay, Unless there's any other questions, that'll conclude today's hearing. Thank you. All right, I have one matter that's on for presentation. It's the Heidi Ellis and John Ellis matter. 23-383-08 is the cause.